When I bought my farm, I wasn't just buying land. I was buying peace. 42 acres of rolling fields, a red barn that had seen better days, and a small farmhouse that creaked in the wind like it was whispering stories from the past. After 15 years of city life, noise, traffic, and corporate meetings that drained my soul, I wanted quiet mornings and honest work. What I didn't expect was a war with an HOA president who didn't even live on my property. I noticed the tire tracks before I noticed her. Fresh grooves cut straight across my east pasture, slicing through the grass like scars. At first, I thought maybe it was a lost delivery truck. Maybe someone had taken a wrong turn. Then I saw the broken fence post. That wasn't an accident. Someone had driven through intentionally. I fixed the fence myself that evening.
Hammer.
Nails.
White. Sweat.
I told myself it was probably a one-time thing. I was wrong. 3 days later, I saw her. A white SUV bouncing across my pasture, like it was some kind of shortcut highway.
No hesitation.
No slowing down. Just straight across my land toward the neighboring subdivision. I jumped into my truck and intercepted her near the tree line. She rolled down her window with an expression I would come to know very well, annoyance mixed with superiority. "Yes," she said, like I was the inconvenience. "You're on private property," I told her calmly. "You just drove through my fence." She blinked like I had insulted her. "This connects to Willow Creek Estates. I use this route all the time." "Well, you won't anymore." She sighed dramatically. "I'm the HOA president of Willow Creek. We've been using this access road for years." I looked around at my pasture. "This isn't a road." She smiled thinly. "It's always been open."
No. Irrablia.
"It's always been mine." After some digging, I found out what had happened. The previous owner of my farm had been elderly. In his final years, he'd stopped maintaining the east fence. Over time, residents of the subdivision behind my property had started cutting across the corner to shave 5 minutes off their commute. It wasn't legal. It wasn't recorded. It was convenience. And convenience apparently had turned into entitlement. After I repaired the fence again, this time with reinforced posts, Karen showed up at my front gate. This time, she didn't smile. "You can't block access," she said. "I just did." "You're interfering with established community usage." "There's no easement on record," I replied. "I checked with the county." She folded her arms. "We'll see about that." 3 days later, my fence was cut. Cleanly. Deliberately. And the tire tracks were back. I installed trail cameras. Motion sensors. Clear private property. No trespassing signs every 50 feet. The very next morning, my phone buzzed with footage. There she was.
Karen. Sunglasses on.
Coffee in hand. Driving straight through like she owned the place. I saved every clip. Every timestamp. Every license plate image. Because at that moment, I realized something important. This wasn't about shortcuts. It was about control. A certified letter arrived a week later. It claimed that my obstruction of the pathway violated historic access rights of the Willow Creek community. It demanded I remove the fence or face legal action. I laughed out loud. They were threatening to sue me for blocking trespassers from driving across my own land. But I didn't respond emotionally. I responded legally. I hired a property attorney named Daniel.
Calm.
Methodical. Unimpressed by drama. He reviewed everything. No recorded easement, he confirmed. No right-of-way. No agreement. What they're trying to claim is prescriptive easement. Meaning, they're hoping long-term use gives them rights. Does it? Not when the use wasn't hostile, exclusive, and continuous under legal standards. And especially not when the previous owner never granted formal permission. He smiled slightly. They're bluffing. Good. Because I was done playing nice. One morning, I walked out to find deep ruts carved into my freshly planted field. She hadn't just crossed the pasture. She'd driven through my new crop line. Seeds I had planted days earlier were destroyed. That was it. No more warnings. No more polite conversations. My lawyer drafted a formal cease and desist letter. It included photo evidence, video footage, county property map, survey documentation, a demand for immediate cessation. It also stated that continued trespassing would result in civil damages. Karen responded the only way she knew how, by ignoring it. The next time she drove across my land, I didn't confront her. I called the sheriff. I showed them the footage, the broken fence, the crop damage, the written notice. They waited at the tree line. When she came through again, lights flashed behind her SUV. The look on her face was priceless. She tried the same line. "We've always used this road." The deputy's response: "Ma'am, this is private property. You've been formally notified. This is criminal trespass." She sputtered. "This is harassment." "No," the deputy said calmly. "This is enforcement." She was issued a citation on the spot. For a week, I received angry emails, anonymous complaints. One even accused me of hurting community unity. Community unity. They were upset because they had to drive around the long way. Meanwhile, I was repairing fences and replanting crops because of their so-called unity. I didn't respond to a single message, because something bigger was already in motion. My attorney filed for damages.
Crop destruction.
Fence repairs, land restoration, legal fees, and punitive damages for repeated trespass after formal notice. The HOA tried to defend her, but when the footage was presented in court, multiple angles, multiple dates, clear signage visible in every clip, the judge didn't look amused. Karen's attorney argued that the path had been used for years. The judge asked one simple question: was there ever a recorded easement? Silence. Was there written permission? Silence. Then this is trespass. Gavel. Karen was ordered to pay for crop damage, cover fence repairs, reimburse legal costs, pay additional penalties, and the HOA. They were formally warned against further harassment. But I wasn't done. My lawyer suggested something permanent. We filed to formally reinforce boundary enforcement with the county, including updated surveys and recorded notice of no easement. Then I built something Karen couldn't argue with.
Apropé, permit agricultural barrier fensa.
Steel posts, reinforced panels, locked access gate, security signage, and one very visible camera mounted at the entrance. It wasn't aggressive. It was legal. Completely. Undeniably. Legally. The driving stopped. Completely. No more tire tracks. No more broken fences. No more entitlement disguised as tradition. Months later, I heard Karen step down as HOA president. Apparently, residents weren't thrilled about the legal fees she caused the association. Funny how that works. Now, mornings are quiet again. Sunrise over the pasture. Wind through the grass.
No engines. No shortcuts. No Karen.
I didn't win by yelling. I didn't win by threatening. I didn't win by revenge. I won by documentation, by patience, by law. And that's how I ended it, the legal way.